This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
In the state of Florida, having your child sleep at your house for 72 nights a year versus 73 nights a year can literally completely rewrite your financial reality.
Yeah, it's a massive difference.
It really is. So welcome to this deep dive. Today, we're taking a heavily requested journey into the actual mechanics of Florida statute, section 61.3 vir.
Which, I mean, if you're standing in your kitchen in Broward County right now, just staring at a recently served petition for child support, I know it feels incredibly overwhelming.
Oh, absolutely. The sheer volume of financial forms is terrifying. So our mission today is to decode that paperwork for you, like stripping away the legalese and looking directly at the state-approved guidelines worksheet.
Right, and we're looking at specific, recent appellate case law governing exactly how a judge in Broward County is going to view your income.
Exactly. And to be clear, we are mapping out the landscape of this law.
Yeah, we aren't here to give legal advice, obviously, or tell you what litigation strategy to pursue. The objective is just for you to understand the underlying mechanics.
Because when you know why a specific number goes into a specific box on an affidavit, the whole process just becomes way less intimidating.
Totally. It takes the mystery out of it.
So, okay, let's unpack this. Where does the math actually start? Because if the court is going to order a transfer of funds, they first have to establish the total pool of resources, right?
Yes. Under Florida law, that means defining gross income first.
And if I'm reading section 61.30 correctly, the state casts a really wide net to figure out what you're actually bringing in.
Oh, they leave very few stones unturned. I mean, gross income obviously includes your standard salary and hourly wages.
Sure, the basics.
Right. But it aggressively captures almost any incoming cash flow. So bonuses, commissions, overtime tips.
What about if you own a business?
For business owners or independent contractors, the statute defines that as gross receipts minus ordinary and necessary business expenses.
Okay, that makes sense.
But it also pulls streams of revenue you might assume are completely off limits, like disability benefits, workers' comp, and even unemployment.
See, the detail in the statute that genuinely stopped me in my tracks was the treatment of Social Security.
Oh, yeah, that's a big one.
Because if a child receives Social Security benefits, specifically because one of their parents is retired or disabled,
the state actually counts those child's benefits as the retired parent's gross income.
Wait, really? The child's money counts as the parent's income?
Yeah, it's a fascinating philosophical stance by the legislature. The state views those specific benefits as a direct replacement for the earning capacity that the parent lost.
Ah, I see. Because of the retirement or disability.
Exactly. That money is flowing to the child because of the parent's status. So the court essentially credits it to that parent's side of the ledger.
Before they calculate the total obligation. Wow. But they do draw a hard line when it comes to public assistance, right?
Yes, they do. The statute explicitly excludes programs like temporary cash assistance.
Which makes sense. I mean, the underlying logic is that the state isn't going to tax the ultimate safety net. You can't squeeze blood from a turnip.
Right, exactly. But once the court has gathered every possible dollar into this gross income bucket, we hit reality.
Right, because nobody actually takes home their gross income.
Nope. We all have deductions.
But looking at the approved deduction list, I have to ask you about, like, personal financial responsibility.
Okay, go for it.
So if you, the listener, choose to responsibly put, say, 20% of your paycheck into a voluntary 401k or IRA, that lowers your take-home pay. Does the court care about that?
The short answer is no.
No, at all.
Not at all. And this is one of the most crucial distinctions in family law. When moving from growth to net income, the law only permits mandatory deductions.
So voluntary retirement contributions are just completely disregarded.
Completely. No matter how financially responsible they are for your future, the court doesn't care.
Because I guess the state's perspective is that your obligation to feed your child today takes absolute precedence over your desire to retire comfortably tomorrow.
That is the exact legal philosophy at play. The allowable deductions strip away all your lifestyle choices.
Wow, okay. So it just leaves the unavoidable financial realities. What's actually on that strict list?
Well, federal, state, and local income taxes, but calculated based on your actual current filing status.
Okay, taxes, obviously.
Mandatory Social Security and Medicare taxes. Mandatory union dues.
What about mandatory retirement? Like for teachers or government workers?
Yes, mandatory retirement payments are allowed, which usually only applies to those specific government or pension-backed employees.
Got it. and health insurance.
You could deduct the health insurance premiums you pay, but only for your own personal coverage, not the child's coverage yet.
Ah, okay, so just your own.
Right.
Yeah.
And finally, any court-ordered support you're actually paying for other children from previous relationships.
And as a practical matter, you can't just, estimate these numbers, right? You have to document every single penny.
Oh, absolutely. On a sworn financial affidavit.
Which, if your annual gross income is under $50,000, you're filling out Form 12.902B.
Yes. And if it's $50,000 or over, you have to use the long form, which is 12.902C.
And you're backing this up with pay stubs, tax returns, bank statements, the works.
Everything. So once both parents have successfully stripped their gross income down to their statutory net income, the court adds those two numbers together.
And that combined monthly net income is basically the engine that drives the entire child support calculation.
Exactly. This is where we hit the statutory guidelines grid.
Right, because instead of letting judges arbitrarily decide how much a child costs, Florida uses this actuarial table, right?
Yeah, it standardizes the cost of raising a child based on combined income. It starts at a combined monthly net income of $800 and caps out at $10,000.
So it acts as the presumptively correct basic monthly obligation.
Right. The state has just predetermined that at specific income brackets, families typically spend a specific amount of money on their children.
Okay, let's ground this for the listener with a real example from the sources.
Sure.
Let's say you and your co-parent have a combined net income of $3,000 a month. You slide your finger across this grid, and the state declares the basic obligation for one child is $644.
And if you have two children, it jumps to $1,001.
Right, and 3 children is $1,252, scaling all the way up to $1,647 for 6 kids.
Yeah, it goes all the way up. But we should briefly mention the edge cases.
Like, what happens if you're not on the chart?
Right, so if the combined income falls below that $800 minimum, the court handles it case by case, referencing federal poverty guidelines.
So they ensure the paying parent isn't left completely destitute, but they still establish some payment principle.
Exactly, and on the other end, if the combined net income exceeds $10,000 a month, a percentage formula kicks in.
Oh, I see. So for one child, it's like 5% of whatever income exists above $10,000.
Yes, 5% is added to the grid's maximum base amount.
Okay, so we have a base number from the grid. How does the court actually determine who pays what portion of that $644 or $1,001?
Well, it comes down to proportional shares, and the math here is incredibly rigid.
Walk me through it.
So if parent A has a net income of $2,000 a month, and parent B has a net income of $3,000 a month, their combined total is $5,000. Parent A is bringing exactly 40% of the total income to the table. Parent B is bringing 60%.
So if you are the listener bringing that $3,000, you are permanently on the hook for 60% of that final statutory number,
Yes.
regardless of what your actual rent or, personal car payment is.
Yes. Your personal living expenses do not alter that percentage at all.
Wow. Okay.
Furthermore, that exact 40-60 split dictates how you handle the statutory add-ons.
Right, because the grid number only covers basic needs, right? Like food, shelter, clothing.
Exactly. The court also mandates the division of childcare costs, specifically daycare required for employment or education, and the child's health insurance premiums.
Okay, so they calculate the total cost of daycare and health insurance divided by that same 40-60 split, and then what?
Then they give a mathematical credit to whoever's actually swiping their debit card to pay the provider.
Ah, so you're essentially just reimbursing each other to ensure the final out-of-pocket burden matches that 40-60 ratio.
That is the exact mechanism.
Which feels highly logical, assuming one parent has the child the vast majority of the time and is incurring all those daily household costs.
Right. But
here is where it gets really interesting. What happens when both parents are heavily involved and practically running 2 households?
this is exactly why the legislature created the substantial time-sharing adjustment.
Ah, this is where we hit that critical 73 overnight threshold we teased at the start.
Yes, because 73 overnights is exactly 20% of a 365-day year.
Okay, so once you hit that magic number.
The moment both parents host the child for at least 73 overnights, the basic grid calculation is just thrown out. The court must use the gross-up method.
The gross-up method. So under this, before you even look at daycare or health insurance, the court takes that base need from the grid and multiplies it by 1.5.
Exactly. They inflate the total obligation by 150%.
So this 1.5 multiplier exists because you're essentially funding duplicated costs, right?
Yes, the duplication of infrastructure.
Like, you're splitting one company into 2 branch offices. You now have 2 internet bills, 2 sets of groceries, 2 sets of school supplies.
That is the perfect way to look at it. The overall cost of raising the child across 2 distinct homes is just higher.
So the pie gets 50% larger. But figuring out who owes what requires a cross-multiplication step that routinely confuses people.
Oh, confuses everyone.
Yeah. So let me map this out slowly. If I'm the listener, and my income means I'm responsible for 60% of that new inflated base need, I don't just pay that 60%.
Right, you do not.
The statute says I have to take my 60% share and multiply it by the percentage of overnights the child spends at the other parent's house.
That is the mechanic.
Yeah.
And you do that because you're essentially compensating the other parent for the time they're operating that second franchise location.
Oh, I see. They are incurring the daily out-of-pocket costs of feeding and driving the child around during those specific overnights.
Exactly. And then they perform the exact same cross-multiplication for you.
Taking their 40% financial share and multiplying it by the days the child is at my house.
Yes. And once you have those 2 final numbers, you simply find the difference between them.
And the parent with the higher resulting number owes the parent with the lower number that difference.
Precisely. Then you add the daycare and health insurance back in, adjust for who pays, and that's your final transfer amount.
It's a dizzying bit of math if you try to do it in your head.
It really is.
But thankfully, this entire gymnastics routine is laid out chronologically on lines 10 through 21 of Form 12.902E.
Right. The form handles the heavy lifting, as long as you input the correct net incomes and the correct number of overnights.
Okay, so that all sounds straightforward, assuming people are being honest. But what does this mean if the math is a lie?
What do you mean?
Like, what if a parent intentionally quits a high-paying job to work part-time just to lower their child support?
Well, the courts are highly attuned to that kind of gamesmanship.
I would hope so.
Under Section 61.302B, if a judge finds a parent is voluntarily unemployed or underemployed, they can invoke income imputation.
Income imputation. So they just legally pretend you make a salary that you don't actually make.
Legally speaking, yes. The court treats the parent as if they are earning an amount commensurate with their true earning potential.
And there's this wild procedural trap here with default judgments, the automatic census rule.
Oh, yes, the automatic imputation.
If a parent just ignores the lawsuit, doesn't file their financial information, the court automatically imputes income equivalent to the median full-time worker based on U.S. Census data.
Yep. The ultimate takeaway is that in family law, silence isn't golden. It's incredibly expensive.
Just sticking your head in the sand opts you into the median national tax bracket. That is wild.
It is. But there are statutory protections built into this system.
Like, a judge can't just invent a 6-figure salary for someone because their ex claims they're a genius.
Right. The law establishes strict boundaries. First, a court cannot impute income based on employment records older than 5 years.
Okay, so the historical data has to be relatively fresh.
Exactly. Second, they cannot impute an income level the parent has never earned, unless they just got a new degree or license.
Got it.
And, most importantly, they cannot impute if the underemployment is due to a physical or mental incapacity or something completely beyond their control.
So the reduction in income must be a voluntary choice.
Yes.
Which brings us to how this plays out in the courtroom. Since our listener is in Broward County, they might be wondering about local rules.
Well, based on the 2024 materials from the Broward County Bar Association, there are no local deviations.
No local tricks.
None. The 17th Judicial Circuit applies the exact same statewide standard.
Okay, so if we connect this to the bigger picture, how does a judge actually implement that?
It requires a very rigid 2-step test, which was clearly affirmed by the appellate courts in cases like Campbell v. Jara.
Okay, walk us through this 2-step sequence.
Step 1, the court must explicitly determine on the record that the unemployment or underemployment is voluntary. Step 2, only after establishing that, the court calculates the imputed amount based on recent work history, qualifications, and prevailing community earnings.
So if I'm the one paying and I'm frustrated, can I just walk into court and say, my ex is lazy, impute them for $80,000?
I mean, you can say it, but it will fail entirely without proof.
Right.
The burden of proof rests entirely on the person asking for the imputation. You have to present competent, substantial evidence.
And we have a definitive ruling on this from the 4th District Court of Appeal, right? The one covering Broward.
Yes, the case of Burkhart v. Das.
What happened there?
The court ruled that a trial judge's written order must make a specific factual finding of voluntary underemployment. They called it the linchpin for imputing income.
And the math the judge uses has to be easily ascertainable from the record. They can't just pull a number out of thin air.
Exactly. And to give a reality check on what counts as evidence, there's a 2024 case from the 2nd District Court of Appeal, AAVMA.
Oh, this case is fascinating. The trial court looked at a father working as an accountant, but he wasn't logging 40 hours a week.
Right. And the judge basically told him to go get a second job to make up the difference and imputed income on that assumption.
Which sounds reasonable if you're just trying to ensure a child is supported.
It does, but the appellate court reversed it entirely because the parent requesting the imputation failed to provide actual evidence. They didn't even ask the father why he wasn't working a second job.
They didn't have a vocational expert. They didn't show that part-time accounting jobs were actually available in the community. They just assumed.
And assumptions are not evidence. Also, there's a massive caveat that ties directly back to our time-sharing rule.
Oh, the 50-50 custody schedule.
Yes. The court must consider if a 50-50 schedule practically limits a parent's ability to work certain hours. You can't always work night shifts or travel if you're heavily parenting.
That makes total sense. Well, we've covered incredible ground today. We started with the sheer panic of an envelope in Broward County.
We really did.
But look at the map we have now. We know how to find gross income, strip it down to net with only mandatory deductions.
Right, ignoring the voluntary retirement.
Exactly. We know how to run that through the magic chart for the basic obligation, split it by proportional shares, and adjust for the 73 overnight rule.
Inflating the base need by 50% for those duplicated household costs.
And finally, understanding the strict evidentiary hurdles of income imputation in Broward County.
Yeah, you have to prove it with that two-step test.
Now, obviously, to the listener, having this map doesn't replace an attorney, but it does take the terrifying mystery out of being served with paperwork. You know exactly what forms matter now.
You do. But, this actually raises an important question that I think we should leave you with.
Oh, let's hear it.
So the law strictly says a court cannot use income records older than 5 years to impute your wages.
Right, as a protection.
But in a rapidly shifting economy where entire industries can become obsolete or change pay scales in just 2 or 3 years, does that 5-year look-back period actually reflect a parent's true earning potential today?
Wow, that is a great point. A 5-year-old W-2 might belong to a career path that literally doesn't exist anymore.
Right, something to really mull over as you gather your financial documents.
Absolutely. Well, to everyone listening, the next time you get a heavy envelope in the mail, hopefully the math inside feels a lot less intimidating. Thank you for taking this deep dive with us, and we will catch you next time.